Hello everyone, welcome back to Courts Today by Livelaw, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. The counsel appearing for Kutum, that is the petitioner organization, referred to various similar incidents in cities Mukherjee Nagar and Vivek Vihar areas and said that despite judicial directions being issued to the civic authorities, no steps had been taken. He further said that a letter was sent to the government regarding the illegal operation of Rao's IAS coaching center, followed by 2 reminders, but no steps were taken in the matter. It was contended that lives of the 3 aspirants would have been saved if timely action was taken. The Council for the Municipal Corporation of Delhi, on the other hand, argued that the authorities have been conducting inspections and issued notices to around 75 institutes, with 35 being shut down and 25 sealed. He emphasized that action was being taken and disputed the notion that the MCD was solely to blame. He also pointed out that the complaint regarding Rao's IAS was initially sent to the government of National Capital Territory of Delhi, or the GNCTD, which delayed the action for 22 days. The bench orally questioned as to why the century-old infrastructure was not upgraded in the first instance when the building bylaws were being liberalized. The bench said that because of the freebie culture, the government has no money to upgrade the infrastructure, particularly the city's drainage system, in face of the exploding population of the city. The acting Chief Justice remarked that multi-story buildings were being permitted without proper drainage systems. The civic authorities are bankrupt, unable to pay salaries or upgrade infrastructure. It was noted that the preference for a freebie culture meant that no money was being collected and therefore none was being spent. The court today impleaded Delhi police in the PIL and concerned DCP and the IO and directed them to be present in court with all relevant files on the next date of hearing. The court also directed that the MCD commissioner be personally present in the court. The matter will now be heard on Friday. In a related update, Judicial Magistrate Vinod Kumar of 30 Hazari courts today denied bail to Manoj Kathuria, an SUV driver and businessman by profession who have been arrested in connection with the deaths of the 3 civil service aspirants. Bail was also denied to 4 co-owners of the basement. Kathuria, let me tell you, is accused of forcing a water wave that breached the entrance of the coaching center and led to the flooding of the rainwater in the basement. He was driving his SUV car on the waterlogged road in front of the coaching center. All 5 accused persons are presently under judicial custody till 12th August. The Supreme Court's 9-judge bench today reserved its decision on whether its judgment delivered on 25th July, affirming states' power to tax mineral rights and mineral-bearing lands, should apply on prospectively. The July 25th judgment held by an 8:1 majority that states can levy taxes on mineral rights independent of the Union Law Mines and Minerals Development and Regulation Act of 1957. The majority opinion clarified that royalties are not taxes but contractual considerations. The bench led by Chief Justice D.Y. Chandrachud today heard arguments regarding the recovery of past dues based on this judgment. Solicitor General Tushar Mehta argued against retrospective application, highlighting that it would disrupt industries and lead to a cascade of price increases affecting the common man. He emphasized that past practices were based on the now overruled India Cements Limited versus State of Tamil Nadu judgment, which had stood for over 35 years. Mehta suggested that neither states demand past dues nor private parties seek refunds to balance interests. Senior Advocate Harish Salve and Senior Advocate Mukul Rohtagi echoed concerns about the financial impact on industries if retrospective demands were allowed. Advocate General of Odisha and other states presented varying perspectives on whether the judgment should apply retrospectively, with some states like Jharkhand and Uttar Pradesh supporting the retrospective application. The Advocate General for the state of Jharkhand argued that denying retrospective effect would undermine laws validly enacted by states. He proposed that past arrears could be paid in installments. The Supreme Court had previously upheld similar state laws, and some companies had complied without issue. The Apex Court has agreed to hear a petition challenging constitutionality of Section 43 of Foreign Contribution Regulation Act, or the FCRA. This section allows the central government to appoint agencies like the CBI to investigate matters related to foreign contributions. The petition filed by Advantage India questions the validity of this provision and Rule 22 of the Foreign Contribution Regulation Rules of 2011. The case stems from allegations against Advantage India for misusing 90 crores in foreign contributions. The Delhi High Court had previously upheld Section 43 and Rule 22, confirming that the CBI could investigate under these provisions. The High Court found no arbitrary power in the central government's decision to appoint investigative agencies and clarified that inquiries and investigations can be conducted by different authorities. The Supreme Court has now scheduled the matter for 6th November for hearing. This petition before the Supreme Court challenges the central government's authority to direct investigations and the use of investigative powers under the FCRA. The Supreme Court has today granted bail to Humayun merchant and alleged aide of late gangster Iqbal Mirchi in a money laundering case lodged by the Enforcement Directorate. The bench of Justices Sanjeev Khanna and Sanjay Kumar was hearing an appeal filed by merchant against the Bombay High Court's order that denied him bail this February. It is alleged that merchant was an active participant and a frontman of Iqbal Mirchi. During the investigation, it was discovered that Iqbal had accumulated significant wealth and laundered the proceeds by investing in numerous properties across Maharashtra, falsely presenting them as legitimate. And that merchant had knowledge of the process of generating, placing, layering and integrating the proceeds of crime as given under PMLA. The trial court had noted that he had a prominent role in Iqbal Mirchi's various illegal activities and he assisted and participated in them. The top court, while granting bail, took into consideration that merchant is now 75 years of age and has already suffered actual incarceration for more than 4 years and 9 months. The trial is still pending. However, at the same time, it was clarified that he shall surrender his passport and will not leave India without permission of the trial court. He was further directed to cooperate in the trial and not seek adjournment. And now let me tell you that a Delhi court has today reserved order on the anticipatory bail plea moved by probationer Puja Khedkar, who, as you know, is accused of misrepresenting and falsifying facts in her application for UPSC Civil Services Examination 2022. Khedkar joined the Pune Collectorate as part of her probationary training in June. The allegation against her is that she misused quotas under other backward classes and persons with benchmark disabilities to clear the CSC. An FIR was registered against her by UPSC in the matter. A show cause notice was also issued to her on cancellation of her selection. Khedkar's counsel today sought anticipatory bail and a stay on her arrest, citing a threat due to criminal prosecution and media scrutiny. She argued that the FIR filed shortly after UPSC's notice was premature and that she should be given a chance to defend herself. The counsel further claimed that her mention of fewer attempts was an honest mistake and that her disability certificate was from AIMS and was valid. She highlighted that name changes are common and that Khedkar has consistently answered questions truthfully. She also suggested that the prosecution was actually retaliatory, as Khedkar had lodged a complaint of sexual harassment against a collector who called her in his office, to which she refused. The special public prosecutor appearing for Delhi police submitted that the offence of cheating cannot take place unless someone is duped, and that in this case, UPSC has been duped by Khedkar. He further said that the investigation is at a nascent stage and various documents, including her medical documents, have to be probed. UPSC's counsel told the court that Khedkar's admission that she did not disclose about her earlier attempts was an admission of guilt. The counsel also said that the integrity of the examination system has been breached by Khedkar in complete defiance of the UPSC rules. In the next update, the Madras High Court has overturned a previous decision by a single judge that has quashed show cause notices issued to Tamil Nadu Chief Minister M.K. Stalin and other DMK MLAs. These notices were related to allegations of breach of privilege for displaying gutka sachets in the Tamil Nadu Legislative Assembly in the year 2017. The High Court bench of Justices S.M. Subramanian and C. Kumarappan was hearing an appeal by the then Secretary of the Tamil Nadu Legislative Assembly, who contested the single judge's decision to dismiss the show cause notices against Stalin and the other MLAs. The bench has ruled that issues of breach of privilege should not be dismissed merely because a new assembly has taken over. The bench has emphasized that such matters are significant and need to be addressed for the public's benefit, regardless of changes in the government. The court rejected the argument that breach of privilege proceedings should end with the dissolution of the assembly, stating that if this were accepted, then the purpose of privileges would be undermined. Such a view could lead to a situation where members disregard privileges, resulting in ongoing chaos and repeated breaches. With this, the High Court has now revived the breach of privilege notices issued to Chief Minister Stalin and other MLAs. A single judge bench of Justice M. Nag Prasanna today heard a petition filed by Kannada actor Darshan Thogudeepa, who has challenged an order of the magistrate court rejecting his application seeking home-cooked food, bedding and cutlery in the prison. You must be aware that the actor was arrested in the Renuka Swamy murder case in June this year. His petition refers to Section 30 of Karnataka Prisons Act and says that it allows under-trial prisoners to maintain themselves or purchase or receive proper food, clothing, bedding, etc., subject to examination and to such rules as may be approved by the IGP prisons. The court today remarked that every citizen or under-trial prisoner requires a nutritionist diet, and authorities cannot create a distinction merely because the prisoner is poor, rich, influential, non-influential, or an actor. When Darshan's counsel, relying on the medical certificate, said that he requires nutritional food, the court said that if he needs a special diet, then requirements as per the doctor will be provided. The Uttarakhand High Court has revised its previous order concerning the registration of live-in relationships under the Uniform Civil Code 2024. Initially, on 18th July, the court had granted protection to an inter-religious couple in a live-in relationship, mandating that they register their relationship under the UCC 2024 within 48 hours. However, this order was amended after the State's Council revealed that the UCC 2024 has not yet come into effect. That the Act, which has only received the President's assent and is awaiting a notification from the state government to come into force, includes provisions for live-in couples. Specifically, Section 378 of the Code requires couples to register their relationship within 1 month of entering into it, with penalties for non-compliance. The State's Council informed the court that the necessary notification for UCC 2024's implementation had not been issued, making it impractical to enforce the registration requirement at this time. As a result, the revision bench of Justice Manoj Kumar Tiwari and Justice Pankaj Purohit modified the initial order, expunging references to the UCC 2024 registration. And lastly, in a significant update, the Bombay High Court has said that asking a woman to clean the house and show the same on a WhatsApp video call to the in-laws is a sadist manner of ill treatment. The court said so while refusing to quash an FIR filed under Section 498A against 5 members of a family. A division bench of Justices Ajay Gadkari and Dr. Neela Gokhale was dealing with a plea filed by one Hardik Shah and his family members, booked on a complaint filed by his estranged wife, who alleged that she was subjected to cruelty by the petitioner, his father and 3 married sisters. Among other allegations, the wife alleged that the 3 sisters-in-law interfered in the household work, sitting at their own homes. She alleged that they removed the household help and compelled her to do her household chores. They even insisted that the wife show how she has cleaned the house to them on WhatsApp video calls. The bench noted that the allegations in the FIR prima facie disclose commission of the alleged offence, thus it refused to quash the FIR. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.